Good morning. Roger Gelb here. I'm an attorney in Washington, D.C., and I've been practicing personal injury law for just over 30 years. Today I'm going to discuss cases in Washington, D.C. Those are cases that occur in the District of Columbia, accident cases. If a case needs to be litigated in Washington, D.C., it's a time-consuming, expensive process. And that's mostly because we don't have a viable small claims court system. You can file in small claims in the District of Columbia, but they're capped at a relatively small number, and they're still time consuming in their own right. When I say time consuming, what is time consuming to litigate a normal case in the district? Say its value is over $10,000. It can take up to 2 years to litigate, and it's expensive, several $1,000s. That's money that the lawyer will typically advance on the plaintiff's behalf, on the client's behalf, but ultimately it's deducted from what we recover on the client's claim, if anything. And so we don't want to litigate in the district unless we really have to, unless the case cannot be resolved amicably. So we always want to try and settle the case if we can. But if we're there, the insurance carrier is trying to take advantage of our client, then we'll certainly litigate it. Even once we litigate the case, most of them do settle before trial, but there's no guarantee we won't try the case. So we would prefer to avoid that if we can. How do we avoid that? Well, there's a couple of ways. One, if the defendant driver lives in a state, in another state like Maryland, we can file the case in Maryland. And that's usually a quicker process and even a more successful one in terms of the overall recovery that we may get. But the most important thing to remember in a District of Columbia case is that litigation process. It is long, it is expensive. So we do try our very best to resolve them by way of settlement. Another thing that separates District of Columbia cases from other cases are clients that are insured in the District of Columbia where they live. If they have a District of Columbia policy, then they often don't have something known as PIP, or personal injury protection benefits, available to them. They may have that, but they may not be able to make both a PIP claim and a claim against the negligent party. If they try to do both, they may preclude that liability claim. So we try and avoid that as well. There are a lot of issues in DC cases. Please call me to discuss this. Happy to get into detail with anybody out there that has a question. I'm always available at 202-331-7227. Thank you.